and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. How are you?
I'm very well, thank you. All the better to be here to talk about a new case around prescriptive easements. And this case is actually from the 29th of August from the Upper Tribunal. And the case is called Kingdom Hall Trust and Peter Robert Davies. And it looks at the need for having a capable grantor and grantee, which you'll go into a bit more detail on for us. But could you start by refreshing our memories on prescriptive easements, what they're all about?
Yeah, well, it's a presumed grant as a prescriptive easement. It's a bit of a legal fiction that if you can show, Dalton Angus, which is discussed in the current decision, was the case that really in 1881 really sort of highlighted the requirements. And it depends on acquiescence by somebody in long user as of right without force, secrecy or permission, nec vi, nec clam, nec precario, as they say. And it's got to be a user buyer on behalf of and against the fee simple owner. And the problem areas and what this case was really about was how do you decide what the long user is? Because that's where it gets bizarre. There are three ways of settling the use. The first, we won't bother too much about, it's that user has been since time immemorial, and you know when time immemorial started, Lizzie?
No.
1189.
1189.
Yeah. Do you know why?
No. Do tell us.
It was the date of the accession of Richard I to the crown of England, and it was settled by this first statute of Westminster of 1275. But that need not bother us. The other ways are under the Prescription Act, one of the worst drafted pieces of legislation of all time until the Building Safety Act came along. But 1832 Prescription Act in Section 2 says if you can show long user as of right, the rights to light are different, for the relevant period. After 20 years, you can get a claimed easement by prescription, but after 40 years, it becomes indefeasible. But it's got to be the 20 or 40 years next before some suit or action, the 20 or 40 years before you bring your claim. And if there's an interruption for a year, then you lose the right, within to claim by prescription. But there's another way, lost modern grant, which is, I say, a fiction that if you can show 20 years, then the fiction is that you've been granted an easement in the past and you've lost the grant. And that's the kind of concept there. Do you remember we did a case on it?
Yeah.
Years ago now.
Mm-hmm.
With a long name. Hughes.
I can't remember the rest of it.
Hughes and the incumbent of the benefice of Frampton-on-Severn, Arlington, Saul, Frethern and Framelode.
That was it. We'll link it in the bottom of this episode if people want to watch it.
Easy to remember. And it's unlike the Prescription Act, where the 20 or 40 years has to be before you claim. That can be at any time in the past. So they've got 20 years user in the past, hadn't used for 4 years this right of way, but they could still claim it. It wasn't actually discussed in this case, this particular case. But there you go. So that's some of the background. Lost modern grant is an easier way of claiming, if you like, than prescription under the Prescription Act.
So can you tell us about this case in particular then? What's happening here?
I'd say this is about that, but primarily about the need for a capable grantor, the person who you're claiming the easement against, and the ability to grant it. It was the Kingdom Hall of Jehovah's Witnesses in Telford, is the Kingdom Hall. And this land until 1958 was in common ownership, and if it's in common ownership, you can't claim prescriptive rights. You'll be claiming against yourself. But part of the land had been separated in 1958, and eventually it was called the Bungalow, and eventually became known as Pleasington or Pleasington, probably. And they were claiming, Davis was the current owner of Pleasington. He was claiming a prescriptive right exercised by him and his predecessors across the passageway, across a car park at the back of Kingdom Hall. There is no evidence of any user which was accepted by the First Tier Tribunal between 1958 and 1977, but between 1977 and 2021, when the dispute arose, there was evidence of use. So on the face of it, you've got your 20 or 40 years user. But there was a problem, and that was that in 1967, the land became charitable land. This is when Kingdom Hall, or its predecessors to be precise, took it over. If it's charitable land, you can't dispose of it. At the time, it would have been Section 29 of the Charities Act of 1960, but it's in the 2011 Charities Act now, sections 117 to 123, if you're interested. And you have to get the consent of either a court order or the consent of the charity commissioners, or the charity commission as it is now. And there was no consent. So what's the status there? You can't, on the face of it, between 1967 and 2021, claim a prescriptive easement. There'd been a case, for instance, which was quoted, Oakley and Boston, 1976 Court of Appeal case, where they basically said you can't presume consent of the charity commissioners automatically. It was claiming a easement. Well, and they sort of quoted that this was actually ecclesiastical land, and you have to get the consent of the ecclesiastical commissioners if it's ecclesiastical land, glebe land, rectorial land. And they said that you can't infer that consent, and they accepted the same for the charitable land here. There's quite a few cases that say the same thing. But all the cases that deal with it are basically, there was no suggestion that the land had been used and the like, so there was a capable grantor before it became charitable land or before it became ecclesiastical land, which is the difference here.
And what was the decision?
There seems to be remarkably little sort of clear evidence, as to this area, but they were quoting cases. Took me back. McGarry Wade, the law of real property, which I studied meticulously when I was a student, and also a couple of law commission papers, and came to the conclusion that, as I mentioned, all the previous cases, there was no suggestion that there was any kind of time period that there might have been a capable grantor. But the tribunal and the Upper Tribunal accepted it, decided that there could have been a grant, a presumed grant. It doesn't have to be a grant, obviously, between 1958, when the land was divided, and 1967, when it became charitable. So you can have two different time periods, one to decide the length of time for the prescriptive right, and secondly, a quite separate time period where there was a capable grantor. And so they got their right. They also said, going back to what we talked about previously, that you could claim under lost modern grants because at any time in the past you've got 20 years user. So that was the decision, and it's quite important.
And are you going to tell us why? What's the consequence of this?
It's always been accepted that it's very difficult to claim prescriptive rights over things like charitable land. I mean, there are other cases. There was a rights to light called Barker and Richardson in 1821, where it was glebe land, and they said, again, you can't claim prescriptive rights. You've got to get the church's consent and the likes. But it seems that you can have two separate time periods, one for the length of time for prescription and one for a time before that when it wasn't charitable land. And there's 167,000 charities in Britain. Would you like me to list them?
I don't think we've got time now.
Okay. And there's also provisions in relation to some university land, which is subject to consents to dispose of. Statutory undertakers, ecclesiastical land, as we mentioned. There's various things. Playing fields, school playing fields, you've got to get the Secretary of State's consent to dispose and so on. So it's quite significant for a larger number of areas. They are potentially subject to prescriptive rights. There you are.
Well, thank you very much, Richard.
Thank you, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.